Beth Cronin is here to speak on behalf of the American College of OBGYN. While I wish I did not need to be standing here today, on a day none of us will forget, I'm standing here as the chair of the Rhode Island section of the American College of OBGYNs, representing OBGYNs across our state. ACOG strongly condemns the U.S. Supreme Court's decision in the case of Dobbs v. Jackson as a direct attack on the patient-physician relationship and the practice of medicine. This decision upends the public health infrastructure in our country and the values we as healthcare professionals hold dear. By putting physicians in fear of the retribution for providing evidence-based, appropriate, life-saving care and denying patients the ability to turn to their trusted physicians for essential health care, this decision fundamentally, irreparably, and devastatingly compromises the patient-physician relationship. Legislative interference affects healthcare practitioners across the spectrum of care, not just OBGYNs. Singling out medical procedures, defying current well-established medical practice and scientific facts, and dictating the care a clinician can or cannot provide sets dangerous precedent for the practice of medicine. Pregnancy can be a high-risk time in a person's life, particularly for those with medically complex conditions. Our country's maternal mortality rates are already unacceptably high. Black women have a 3- to 4-fold higher maternal mortality rate compared to white women. This decision will take us backwards. The harm the U.S. Supreme Court's decision will be experienced most acutely on the communities that are already systematically marginalized, exacerbating unacceptable inequities in our healthcare system. The consequences of this decision will be sweeping, not only by opening the floodgates to widespread bans on abortion, but also for what it represents: a frightening era for healthcare professionals who must fear criminal, professional, and civil penalties for providing evidence-based appropriate care. The court's decision will have devastating ripple effects, and this legislative interference will not stop with abortion. Its chilling effect will impede miscarriage and ectopic pregnancy management, may threaten infertility treatment, and fuel efforts to target other essential care, including contraception and gender-affirming care. With the passage of the Reproductive Privacy Act in 2019, abortion remains legal in Rhode Island today. We can continue to provide safe abortion care for all patients in our state. However, I have countless colleagues around the country who now cannot provide essential care for their patients due to legal risk. We need to help fight for them, their patients, our friends across the country. We are committed to mitigating the fallout of this decision. We will continue to serve our patients to the best of our abilities while accommodating patients seeking care from outside our borders. As President Biden said earlier today, this fall, Roe is on the ballot. Personal freedoms are on the ballot. Please do your part and vote. Ensure that the Reproductive Privacy Act remains law in Rhode Island. Help elect legislators who will work to improve equitable access to abortion in our state through the passage of the Equality and Abortion Coverage Act. Please continue to speak up, advocate, and fight. We have so much more work to do. Thank you.